Today we will discuss about the introduction to Philippine taxation. The objectives of this training is for you to be able to visualize the overview of Philippine tax system, to know the similarities and differences of the three inherent powers of the state, and to evaluate the different theories, principles, and taxes governing the Philippine tax system. When the sovereign state is born, it exists with absolutely necessary powers for its survival. These powers are called inherent powers, meaning to say they naturally exist as essential force in order for the government to command, maintain peace and order, and survive irrespective of any constitutional provision. The three inherent powers of the state are the following. First is the police power. It is the power to protect citizens and provide for safety and welfare of society. Second is the taxation power. It is the power to enforce contributions to support the government and other inherent powers of the state. And lastly, eminent domain power. It is the power to take property with just compensation for public use. Just compensation means paying the owner the full monetary equivalent of the property taken for public use. These inherent powers have similarities as follows. Inherent in the state, meaning to say these powers exist already with the government or with the state. Exist independently of the Constitution, which means that we don't have to enact laws for these powers to be exercised. Ways by which the state interfere with private rights and property. Legislative in nature and character. In general, only the Congress or the legislative branch of the government can exercise this power. And lastly, presuppose an equivalent compensation received. Inherent powers of the state have also differences as to categories. So as to concept, the police power makes and implements laws for the general welfare. The eminent domain takes private property for public use with just compensation. The taxation power raises government funds. And as to scope, police power is broader in application. It is a general power to make and implement laws. The eminent domain, it is merely a power to take private property for public use, while taxation power, it is plenary, comprehensive, and supreme. As to authority, police power, it is exercised only by government or its political subdivisions. Eminent domain may be granted to public service or public utility companies. Taxation power, exercised only by government or its political subdivisions. As to purpose, police power, the property is taken or destroyed to promote general welfare. Eminent domain, property or private property is taken for public use. Taxation power, money is taken to support the government. As the necessity of delegation, the police power, it can be expressly delegated to the local government units by the lawmaking body. The eminent domain, same with the police power, it can also be expressly delegated to the local government units by the lawmaking body. And taxation power, the power to make tax laws cannot be delegated. As the person affected, police power, it operates on a community or a class of individual. Eminent domain, it operates on the particular private property of an individual. And taxation power, it operates on a community or a class of individual. As to benefits, police power help the economic standard of society. Eminent domain, market value of the property expropriated. Taxation power, continuous protection and organized society. As to amount of imposition, For police power, cost of regulation, license and other necessary expenses, eminent domain, no imposition, taxation power, generally no limit. As to importance, the police power, protection, safety, and welfare of society, eminent domain, common necessities and interests of the community transcend individual rights in property, taxation power, inseparable for the existence of a nation, it supports police power and eminent domain. As to limitation, for the police power, limited by the demand for public interest and due process, for the eminent domain, bounded by public purpose and just compensation, while taxation power, it constrains by constitutional and inherent limitations. As the relationship to constitution, police power, relatively free from constitutional limitations, superior to non-impairment clause, eminent domain, superior to and may override constitutional impairment provision because the welfare of the state is superior to any private contract. Taxation power, subject to constitutional and inherent limitations, inferior to non-impairment clause. After discussing the definition, similarities, and differences of the inherent powers of the state, let us now focus on taxation power alone. Purposes of taxation. There are purposes why taxation is being exercised. First is revenue or fiscal. The primary purpose of taxation is to raise revenue to defray the necessary expenses of the government. Another purpose is regulatory. It aims to regulate inflation, achieve economic and social stability, which means that taxes may be imposed to encourage economic growth by granting tax exemptions or incentives to attract investments that will eventually create employment to the citizens. Serve as instrument for social control. A good example on this is taxes on importation. A country can impose higher taxes on customs and tariff rates on imported products if they would like to restrict or lessen trade relations with some foreign countries. On the other hand, a country may reduce taxes on importations if they would like to open trade relations with foreign countries. The next purpose is the compensatory. It is giving back the expected economic and social benefits due to the inhabitants. An example for compensatory is excise tax on gasoline consumed imposed on vehicle owners using roads. So, the tax is compensatory for the use of road. The nature of taxation power are as follows. Inherent power of the state, meaning to say, from the moment the state is born, it automatically possesses the power to collect taxes from its inhabitants. Essentially a legislative function. The lawmaking body of the government and its political subdivisions exercise the power of taxation. For public purposes, taxes collected from its inhabitants must be used to finance public needs such as healthcare, education, security, and others for the welfare of the general public. Next is territorial in operation. Countries' tax laws are effective and enforceable only within its territorial jurisdiction except when there exists a privity of relationship between the taxing state and the object of tax based on the principle of reciprocal duties. Tax exemption of government. It applies only to government entities through which the government immediately and directly exercises its governmental functions. Strongest among the inherent powers, Taxation power is the strongest among the three inherent powers because without fund or money which came from the taxes being collected, the government can neither survive nor dispense any of its powers and functions effectively. Last is taxation power is subject to constitutional and inherent limitations. Limitations on the taxing power. As mentioned, one of the nature of taxation is it is subject to limitations, the inherent limitations and the constitutional limitations. Let us discuss first the inherent limitations. These are the natural restrictions to safeguard and ensure that the power of taxation shall be exercised by the government only for the betterment of the people whose interest should be served, enhanced, and protected. Number one is for public purpose. So the taxes being collected from the citizens or inhabitants must be used to finance public needs. Number two, non-delegation of the taxing power. The nature of taxation is it is legislative function. Thus, the power to make tax laws cannot be delegated or cannot be exercised by the executive or judicial branch of the government. But when the power to tax is delegated to the local government units or LGUs, only the legislative branch of the LGU can exercise the power. Also, if it is delegated to the president, it is limited only to the administrative discretion subject to valid standards. Next is exemption of the government. So it only applies to government entities through which the government immediately and directly exercises its governmental functions. Number four is international committee. It is an agreement between countries and under international law, some properties may not be taxed by another state. And lastly, limitation of territorial jurisdiction. So, as mentioned on the nature of taxation, countries' tax laws are effective and enforceable only within its territorial jurisdiction except when there exists a privity of relationship. These inherent powers have been mentioned and explained in the nature of taxation. Another limitations on the taxing power is the constitutional limitations. Constitutional limitations are provisions of the fundamental law of the land that restrict the supreme, plenary, unlimited, and comprehensive power to tax by the state. The 1987 Philippine Constitution sets limitations in the exercise of the power to tax as follows. Number 1. Due process of law. Article 3, Section 1 of the Constitution provides that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. The objective of due process of law is to secure the individual from the abusive exercise of the taxing power of the government. Number 2. Equal protection of laws, meaning to say that all persons subject to legislations shall be treated alike under similar circumstances and conditions, both in the privileges conferred and liabilities imposed. The objective of equal protection of laws is to protect persons belonging to the same class against intentional and arbitrary discrimination. Number 3. Rule of uniformity and equity. Article 6, Section 28, Paragraph 1 of the Constitution states that the rule of taxation shall be uniform and equitable, meaning to say all taxable articles or kinds of the same class shall be taxed at the same rate. Number 4. Non-impairment of contracts. Article 3, Section 10 of the Constitution provides that no law impairing the obligation of contracts shall be passed. It is limited in application to laws that derogate from prior acts or contracts by enlarging abridging, or in any manner changing the intention of parties. Number 5. Non-imprisonment for non-payment of poll tax. Article 3, Section 20 of the Philippine Constitution provides that no person shall be imprisoned for debt or non-payment of a poll tax. The meaning of poll tax is it is a tax imposed on a person as a resident within a territory of the taxing authority without regard to his property, business, or occupation. Example for this is the community tax. The non-imprisonment for non-payment applies only to poll tax. Imprisonment for non-payment of other taxes or imposition of fine would not be contrary to the Constitution. Number 6 is origination of appropriation, revenue, and tariff bills. Article 6, Section 24 of the Constitution provides that all appropriation, revenue, or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills shall be originate exclusively in the House of Representatives, but the originate may propose or concur with amendments. The power to tax is legislative in function, so that the Constitution exclusively vested to the Congress the origination of all appropriation, revenue, and tariff bills. Number 7 is President's power to veto. Article 6, Section 27, Paragraph 2 of the Constitution provides that every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, the President shall sign it; otherwise, the President shall veto it and return the same with his objections at large in its journal and proceed to reconsider it. Next is Congress granting tax exemption. Article 6, Section 28, Paragraph 4 of the Constitution provides that no law granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. It means that it shall be observed that the mentioned provision requires the concurrence of a majority not of the attendees constituting a quorum, but of all the members of the Congress as a safeguard against the indiscriminate grant of tax exemptions. Number 9. Exemption from property taxation. Article 6, Section 28, Paragraph 3 of the Constitution provides that charitable constitutions, churches, convents, and non-profit cemeteries and all lands, buildings, and improvements actually, directly, and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. This exemption is granted to them in return for the benefits they have afforded to the public welfare. Number 10. Public money not for religious purposes. Article 6, Section 29 of the Constitution states that no public money or property shall ever be appropriated, paid, or used directly or indirectly for religious purposes. This limitation is fundamentally supported by the principle that taxes can only be levied for public purposes. This doctrine further stresses the principle of the separation of the church and the state. Number 11. The power of judicial review. The Supreme Court shall have the power to review, revise, reverse, modify, or affirm on appeal as the laws of the rules of court may provide. The power of judicial review in taxation is limited only to the interpretation and application of tax laws. Judicial review is limited only to the review where involves the determination of validity on the tax in relation to the constitutional or provision and the determination in an appropriate case of the application of tax law. And lastly, number 12, taxes as the general fund of the government. Article 6, Section 29, Paragraph 3 of the Constitution states that all money collected on any tax levied for a special purpose shall be treated as special fund and paid out for such purpose only. So, meaning to say, such fund shall be used for its intended purpose, and none of its part shall be used for exclusive benefit of any private person. Principles of sound tax system. So these are fiscal adequacy, equality or theoretical justice, and administrative feasibility. Fiscal adequacy. The sources of the government must be sufficient to meet public expenditures. An ideal budget to achieve fiscal adequacy is a balance between government revenue and government expenses. Equality or theoretical justice. It must be based on the taxpayer's ability to pay, and administrative feasibility must be capable of convenient, just, and effective administration. Basis of taxation. Taxation is basically established based on the following principles. First is principle of necessity. Taxes being the lifeblood of the government, their prompt and certain availability are of the essence. The government has a right to compel all its citizens, residents, and property within its territory to contribute money, and every citizen must pay his corresponding tax liabilities. Another principle is the principle of benefits received theory. It is intended for the general welfare. In this case, the government collects taxes in order to be able to perform its functions and services to the citizens. On the other hand, the citizens must pay taxes to support the government in order that he may continuously be sustained with security and benefits of an organized society. In the exercise of taxation power, some underlying doctrines for its implementation are as follows: prospective application of tax laws, imprescriptibility of taxes, double taxation, escape from taxation, exemption from taxation, taxpayer suit, compromises, set of taxes, equitable recoupment, power to destroy, and situs of taxation. Let us first discuss the prospective application of tax laws. Tax bill must only be applicable and operative after becoming a law, meaning to say, the effectivity of the tax law commences upon its approval, and its scope only cover the present and future transactions. Retroactive application of tax laws shall not be applied unless there is a clear intent of the legislature that such law also be imposed on past transactions. Next is imprescriptibility of taxes. The rule on tax imprescriptibility states that unless otherwise provided by the tax law itself, taxes in general are not cancelable. The prescriptive period shall start from the time the taxpayer files the tax return and declares his tax liability. Next is double taxation. It is an act of the sovereign by taxing twice for the same purpose in the same year upon the same property or activity of the same person, when it should be taxed once for the same purpose and with the same kind of character of tax. So, to avoid injustice and unfairness, doubts as to whether double taxation has been imposed should be resolved in favor of the taxpayer. Next is escape from taxation. It permits taxpayer to minimize, if not to escape, payment of tax by lawful means. There are two forms by which the taxpayer could escape from taxation. So the first one is tax evasion and the other one is tax avoidance. Tax avoidance has several types which could be legally used to minimize taxpayers' tax liabilities, and these are tax option, capitalization, shifting, transformation, tax amnesty, tax exemption, and tax condonation. Let us first discuss the first form of escape from taxation, the tax evasion. The taxpayer uses illegal or unlawful means to defeat, evade, or lessen the payment of tax. It is prohibited and therefore subject to civil and/or criminal penalties. An example for this is non-inclusion or non-declaration of sales and fabrication of expenses. The second form of escape from taxation is tax avoidance. It is reducing or totally escaping payment of taxes through legally permissible means, and it is also called tax minimization. Let's discuss the several types of tax avoidance. First one is tax option. It is when the taxpayers may choose to pay lower tax rate in some transactions as permitted by tax laws. An example for this is the taxpayer sells shares of stocks through the local stock exchange instead of selling it directly to the buyer in order to avail lower tax rates. Another type is capitalization. It is a reduction in the price of the tax object equal to the capitalized value of the future taxes which the purchaser expects to be called upon to pay. Example is the seller reduced the selling price of the real property but in the condition that capital gains tax should be shouldered by the buyer. Next is shifting. It is the transfer of tax burden to another without violating the law. So the first type of shifting is forward shifting. So the burden of tax is transferred from the manufacturer, then to the distributor, and lastly to the consumer of the product. The backward shifting, the tax burden is transferred from consumer through factors of distribution to the factors of production. While the onward shifting, the tax burden is shifted two or more times, either forward or backward. Next is transformation. It is when the producer absorbs the payment of tax to reduce prices and to maintain market share. Next is tax amnesty. The state grants general pardon or intentionally overlooked its authority to impose penalties on persons guilty of tax evasion or violation of tax law. Tax amnesty has limited applicability as to cover a particular taxing period or transactions only. Next is tax condonation. The state desist or refrain from exacting, inflicting, or enforcing something as well as to restore what has already been taken. Next is exemption from taxation. It is a grant of immunity expressed or implied to a particular person, corporation, or to persons or corporations of a particular class from a tax upon property or on excise which persons and corporations generally within the same taxing district are obliged to pay. Next is equitable recoupment. It is a tax claim for refund which is prevented by prescription may be allowed to be used as payment for unsettled tax liabilities if arises from the same transaction. Meaning, overpayment is made and underpayment is due, but it is not applicable to cases where the taxes are totally unrelated. Next is set-off taxes. Taxes are not subject to set-off or legal compensation because the government and the taxpayer are not mutual creditor and debtor of each other, which means a person cannot refuse to pay tax for the reason that the government owes him an amount equal or greater than the tax being collected. But there are some exceptions. It is where both claims of the government and the taxpayers against each other have already become due, demandable, and fully liquidated, and when there is an actual compromise between the taxpayer and the tax officer. Next is taxpayer suit. It is effected through court proceedings could only be allowed if the act involves a direct and illegal disbursement of public funds derived from taxation. Next is compromises. Generally allowed and enforceable when the subject matter thereof is not prohibited from being compromised and the person entering such compromise is duly authorized to do so. Next is power to destroy. Taxpayer has no option but to pay the tax imposed to him. The government can compel payment of tax and forfeiture of property through the exercise of police power. Next is situs of taxation. It is the place of taxation or the state or political unit which has jurisdiction to impose tax over its inhabitants. The following are the determinants to the situs of taxation: nature, kind or classification of the tax, subject matter, source of the income, place of the excise, privilege, business or occupation, citizenship and residence of the taxpayer. Situs of taxation. So, situs of tax persons, the basis of taxation is the residence of the taxpayer. For the real property and tangible personal property, the basis of taxation is the location of the property. For the intangible personal property, the basis is the domicile of the owner. For the income, the basis is the residence, citizenship, and source of income. For the business, the basis of taxation is place of business, while for the gratuitous transfer of property, basis of taxation is the residence or citizenship of the transferor or location of property. Taxes are grouped according to the following classifications. The first one is as to purpose. So, general or revenue or fiscal tax and regulatory or special or sumptuary tax. So, for the general, it is imposed solely for raising public funds, while for regulatory, it is imposed for achieving some social or economic goals. As to object or subject matter, personal, poll or capitation tax, property tax, and excise tax. So for personal tax, it is fixed in amount and imposed on persons. Example for this is community tax. Property tax, it is imposed on personal or real property based on its proportionate value. An example for this is real estate tax. And for the excise tax, it is imposed upon the performance of a right or act, the enjoyment of a privilege or the engagement. An example for this is the estate or donor's tax. As to determination of amount, ad valorem tax and specific tax. Ad valorem tax, the imposition is based on the value of the property subject to tax, while specific tax, it is a fixed amount based on volume, weight, or quantity of goods as measured by tools, instruments, or standards. As to who bears the burden, direct tax and indirect tax. So for direct tax, it is personal and cannot be shifted to another taxpayer. Example is community tax and income tax. For indirect tax, the payment of tax falls on one person but the burden can be shifted. An example for this is the value added tax or the VAT. As to jurisdiction or scope of authority, national tax and local tax. National tax is imposed by the national government. Example are income tax, value-added tax, estate and donors tax, excise tax, and documentary stamp tax. Local tax is imposed by the municipal governments. An example for these are community tax, real estate tax, and municipal license taxes. As the rate or graduation, proportional tax, progressive tax, and regressive tax. Proportional tax is unitary or single rate. Progressive tax, as the tax base increases, the tax rate increases, while regressive tax rate increases as the tax base decreases. Tax law. It is a body of laws which codifies all national tax laws. Such law comprises of the Republic Act 8424, entitled the Comprehensive Tax Reform of the Philippines, known as the National Internal Revenue Code of 1997 or Tax Code. Internal Revenue Law. It includes all laws legislated pertaining to the national government taxes, which is embodied in the National Internal Revenue Code. The following national taxes are classified as internal revenue taxes under the administration of the BIR. These are income tax, transfer taxes, estate and donors tax, business taxes, VAT, percentage tax and excise tax, documentary stamp tax, and such other taxes as may be imposed and collected by the BIR. Nature of tax laws. Civil in nature and neither political nor penal, which means that even if there are some penalties provided for violation of tax laws, they are not penal in nature because they do not define crimes and provide for their punishment. The Internal Revenue Law provides for some penalties for tax delinquencies, only to effect timely payments of taxes, or punishes tax evasion for neglect of duty by those subjects of taxation. Interpretation and application of tax laws. The following rules are generally followed for the interpretation and application of various tax laws. First one is tax statute must be enforced as written. So when there is ambiguity of tax laws, the rules of statutory construction may be used to search for the legislative intent. However, when the meaning of the law is clear, the statute must be enforced as written. Next is imposition of tax burdens is not presumed. Tax burdens shall neither be imposed nor presumed beyond what the statutes expressly and clearly state, because tax statute should be construed strictly against the government. Next is doubts should be resolved liberally in favor of the taxpayer. It is because the tax laws impose special burden upon the taxpayer. Next is tax exemptions are extremely construed against the taxpayer. Tax exemptions cannot be established by the mere application, but must be clearly expressed by the law. Tax laws are applied prospectively. It must be applicable and operative only upon becoming a law. Tax laws are given retroactive effect only if there is a clear legislative intent in that regard. And last, tax laws prevail over civil laws. The tax code is a special law in relation to the civil code. So whenever there is a conflict between the tax code and the civil code, the tax code always prevail over civil code. Sources of Philippine tax laws. Philippine Republic makes laws which may be comprised of the following: Constitution of the Philippines, judicial decisions, executive orders, statutes, tax treaties and conventions with foreign countries. Revenue regulations promulgated by the Department of Finance, BIR Revenue Memorandum Circulars and Bureau of Customs Memorandum Orders, BIR rulings, and local government code. So for Constitution of the Philippines, it is a body of rules and maxims in accordance with which the powers of sovereignty are habitually exercised. It is also called the supreme or fundamental law. Next is the judicial decisions. These are decisions for application made concerning tax issues by the proper courts exercising judicial authority of competent jurisdiction. Executive orders. These are regulations issued by the President or some administrative authority under his direction for the purpose of interpreting, implementing, or giving administrative effect to a provision of the Constitution or some law or treaty. Statutes. These are laws enacted and established by the will of the legislative department of the government. Tax treaties and conventions with foreign countries. These are treaties or international agreements with foreign countries regarding tax enforcement and exemptions. BIR Revenue Memorandum Circulars and Bureau of Customs Memorandum Orders. These are administrative rulings or opinions which are less general interpretations of tax laws, being issued from time to time by the Commissioner of the Internal Revenue or Commissioner of the Bureau of Customs as the case may be. Revenue regulations promulgated by the Department of Finance. These are rules or orders having force of law issued by executive authority of the government to ensure uniform application of the tax law. BIR rulings. These are expressed official interpretations of the tax laws as applied to specific transactions. And lastly, the local government code. These are tax ordinances issued by the province, city, municipality, and barrio, subject to such limitations as provided by the local government code and the real property tax code. Tax distinguished from other charges and fees. Tax versus toll. Tax is a demand of the state. It supports for the government. It, im- it is imposed only by the government and it is based on government needs. On the other hand, toll demands of proprietorship. It is a compensation for the use of somebody else's property. It is maybe imposed by the government or private individuals, and it is determined by the cost of property or improvement thereon. Tax versus penalty. Tax is imposed to raise revenue. It is imposed only by the government. It arises from law. Generally, tax is payable in money. On the other hand, penalty is imposed to regulate conduct through punishment and suppression of injurious act. It is may be imposed by the government or private individuals. It may arises from law or contract, and it is paid in money or in kind. Tax versus special assessment. Tax is levied on persons and property. It is a personal liability and based on necessity. It has general application. While special assessment, on the other hand, it is levied on land. It is not a personal liability. It is based on benefits received, exceptional in application for the recovery of cost and or maintenance of improvement. Tax versus license fee. Tax is levied in the exercise of the taxing power. It is used to generate revenue. The amount is unlimited. It is imposed on persons and property. Non-payment of tax does not make the business illegal. License fee, on the other hand, it is exercise of police power. The purpose is regulatory. The amount is limited to the necessary expenses of regulation and control, and non-payment of license fee makes the business illegal. Tax versus custom duties. Tax is imposed on persons and properties and comprehends more than the term custom duties, while custom duties, on the other hand, is imposed on imported or exported goods and it is also a tax. Tax versus debt. Tax is based on law. It is not assignable. It is payable in money. It is not subject to set-off. Non-payment may result to imprisonment and it bears interest only if delinquent. While debt, it is based on contract, it is assignable, payable in kind or in money, and it is subject to set-off. Non-payment may not result to imprisonment, and interest depend upon the stipulation of the parties. And that's the end of my discussion. I hope you learned a lot from our topic, which is Introduction